yeah. Good morning, everyone. On behalf of the Catholic Church, with the Reverend Alfonso Sr. is our pastor, we welcome you to our WIILS versus TRUSTS seminar on today. We thank you for your interest. And right now, our presenter today, Marquise Abraham, and his partner. They will present, but I'm going to pray, and then I'll let them have it and introduce themselves. Amen? We all bow our heads. Heavenly Father, Lord God, we thank you again for another day. We thank you for just blessing us to see this day. So we ask you that this presentation on today will give everybody the understanding that they need to prepare for the future, Heavenly Father, that they may leave their family sound or whatever it may be. All these things I ask in Jesus' holy and righteous name. Amen. Thank you to our amen. Good morning, everyone. Good morning. Nice to see you all. See you okay? No good? Go ahead, keep going. You hear me okay? You hear me okay? There we go.
It was working on speed, sorry. Good morning, everyone. How are you doing today? My name is Marquise Abraham. My law partner and good friend, Dwayne Lattimore. We are Abraham and Lattimore Law Group, and we're extremely excited to be here with you this morning to talk about estate planning. All right? Now, I know it's not necessarily the juiciest topic in the world, but it's a necessary topic, especially with adults like you. So, people like you all I call responsible adults with assets, right? And responsible adults with assets do responsible planning to protect their assets and have a legacy to give to their family and loved ones. So we're going to talk a little bit about what estate planning means today, and I encourage you to ask questions as we go. We'll have time for questions at the end as well, but please feel free to raise your hand. I'll take your questions as we go. I already introduced myself. I just wanted to bring up this picture that I kind of like of myself. In 2 seconds, Now this guy right here, this is a good picture right there, like I said. But obviously, this is my partner, Dwayne, and he's an amazing attorney. Just a little disclaimer, we are working together here to provide information and collaborate so that we have a full understanding of what responsible adults with assets do. We don't represent you yet, so please don't hold us to account for every little thing. We did find a typo in the presentation, but luckily we found it. I think that's the only one. But just bear with us. Our firm, we take our work very seriously. We deal with our clients in a very comprehensive way. We want you to know that you can rely on us to get you the results you need. You should not expect anything but excellence from your attorneys. And if you don't, you're going to find yourself in trouble soon. So, what do we do at Abraham and Lattimore Law Group? We do a few things. We're doing very well. I'm proud to say that. I'm not boasting. It's just a fact of very disciplined practice and really dedication to our clients. We do estate planning. We do real estate law. We do a lot of business and transactional law. And we also do civil litigation on a case-by-case basis. If it's something juicy, something I can go to court and win and make a big deal about, I'll take your case. What are you going to learn today? We're going to talk about that every important asset that you may have, your children, and how you protect them. We're going to talk about intestacy, what happens if you don't plan, and that nasty. We're going to get into your options for estate planning. We're going to talk about wills, we're going to talk about trust, we're going to talk about incapacity planning as well. Meaning, how do you protect yourself while you're still alive? How do you protect yourself and your assets while you're still alive? So, little roadmap for you, where we're going to go throughout this hour or so. And we want you to make notes on the sheet we provided you with the handouts of our slides, also some space to make notes, so please utilize that. Also, we have a worksheet there that will allow you to give some notes, some feedback on the presentation, give us your information, and we'll reach out to you for more discussion. So let's talk about what is an estate. What's an estate? Right? An estate is the grouping or collection of all the assets you may have, an individual may own. Right? And here's some examples as you see that might comprise your estate. You have your bank accounts, maybe your business interests, your retirement accounts, life insurance, valuable collections like jewelry and artwork, real estate, and intellectual property. So all of those could be considered a part of your estate, okay? But there's an important idea about how this becomes your estate or not your estate, right? And that relates to how you title the assets. Okay? Now, titling of assets is extremely important in the concept of estate planning, where we're going to decide how the asset is owned. So obviously you have individual ownership, just one owner, bank account in your name alone. Right? Even if you're married. Jointly, two or more people, two or more owners, husband and wife and mother. I'm dealing with a case right now, a guardianship case. We were doing the asset inventory last night. The prospective ward, if you will, has 3 bank accounts, all joint with his wife, one also with his son in there. So that's the idea of joint ownership of assets, right? You might have a piece of real estate principal home, you and your husband or you and your wife own, something like that. That's joint ownership of assets. And then you have by contract, right? Life insurance policies with a beneficiary that might be payable to. So those are different types of ways you can have title in assets. But there's risk involved in joint ownership of assets, right? And we're going to get to some of these topics in more detail that you might hear as I go through. But one of the risks of joint owned assets is you may avoid probate on the death of the first person, but on the death of the last person, you're not going to avoid probate if you don't have a plan. It's still going to go through probate. So joint ownership really doesn't solve that issue, okay? Now, you might think, okay, I can solve some of that by doing a beneficiary designation if those accounts or those accounts are available. But what happens if you die when the beneficiary is 17 or 18? Let's go back to 17. I like 17 because people don't realize this. And when they're thinking about how they designate their life insurance. You got 2 boys, and 50-50, you know, you pass away, unfortunately, in a car accident, life insurance proceeds paid out, you got a 17-year-old child. Where's that money going? Nope, not quite. But you're on point. You're still 17, he's not an adult. He needs a guardian. Who's the guardian? So you have to select one? If you planned, you would have selected one. If you didn't plan, it's up in the air. It's a court proceeding. It's your sister. It's your grandmother. It's an estranged neighbor that actually is the one who knows the kid and took care of him well, but is trying to fight in court from your relatives who claiming they got all the goods. Why? Because they want that $500,000 in their bank account. Because now they control the money. They're going to take care of your kids well, or they're going to give them a turbo. Now, you might have somebody you know for sure. I got a couple people I know for sure, I'm not worried at all. My estate plan is done. If my son is 17, I know he's going to be well taken care of with that money. But sometimes you just don't know if you don't plan.
What legal action does a godparent have?
You said legal right?
Yeah.
You said right. Legal action. Okay. What legal right does a godparent have? Zero. Okay. So, now if the kid is 18, let me say a little bit more. I'm being a little curt. Godparent, though, is an interested party who has an interest in the matter and who can demonstrate, if they can, that they have the child's best interest in mind. So the court is going to skew toward a family member, but at the end of the day, the court is going to go with who's doing the best for the child. So the godparent doesn't have a right, but they have an interest to intervene and make their application. There's no right, just to be clear on it. 18 years old, where does it go? Straight to the 18-year-old. You like that? I wish I had $500,000 out of 18. Guess how much I would have right now? Zero. I was hoping I get $500,000 so I could spend it all in one day. You're not going to give $500,000 to an 18-year-old. But if you don't plan well, 100% you are. So, the beneficiary designations are good, but they have to be planned out. They have to be with a purpose, with a strategy behind it. All right? Now, no rules, no guardrails to get all the money. And then what if your oldest son becomes estranged because he's under the spell of some conniving woman? Don't take care of you, nothing. Don't come see you, nothing. But you didn't update that beneficiary designation. That no good, about to get $1 million. Gotta update your beneficiary designation. You gotta pay attention to this stuff. You guys are responsible adults with assets. Can't be irresponsible. You gotta maintain your responsibility. Now, what happens when you don't have a plan? It's called dying intestate, right? Without an estate, right? Without a planned estate. So, is there a plan for you if you don't make your own plan? Gentleman over here shaking his head. He got all this morning preparing this like. Is there a plan? Tell me what the plan is. The government has a plan for you. You don't want a plan for yourself. The government has a plan for you. And I'm going to tell you something. I'm going to give you a little sneak peek. Go on ahead. At the end of the day, if you don't have a plan and nobody else is around, guess who gets your stuff? The government. They set it up really nice for themselves, didn't they? You want to go with their plan or you want to go with your plan? Yeah, I think you want to go with your plan. So, if you don't plan, spouse can be married after your death, leave no money to your kids or to the new spouse. Kids get the money outright, that's bad. Children and beneficiaries can lose inheritance to government recovery. Imagine you got an 18-year-old kid, he's running around in the army. He's running around just doing his thing, living life. Passed away, he's in grief. He's not thinking about figuring all of this out. 10 years later, poof, going to the state. Judge, got these judges if you will. People like us. You know what judges used to be? Lawyers, making all type of mistakes. You know what they didn't do when they became judges? Stop making mistakes. You guys have to do it for yourself. Because if you go on appeal, never mind what you lost in probate, appeal is about 2-3 times more. And you know you're right, but can you afford it? talked about this. Here's the typo we found. Because we talked about New Jersey. We practice in both New York and New Jersey. So it's not wrong per se, but we're going to clarify it right now. In New Jersey, if you die without a will, your assets are distributed as follows. If you're married and you have children, and all of your children are with your spouse, everything goes to your spouse, 100%. If you have a mixed bag, the first $50,000 goes to your spouse, 50% of the rest goes to your spouse, and the kids split the other 50%. This is the state's plan for you. You like it so far? You're already going to like it. Let me get down to trust. This is the state's plan for you. If there's no spouse, children get everything. No spouse, no children to your parents. No parents living to your siblings. No siblings living to your grandparents. No grandparents living to your aunts and uncles, and then back to the state. Now, they may be a lot. This is just a little practical note. They may be a lot. You know, you see, you look at it like, well, if everybody dead, I mean, what else are you supposed to do? They may be alive, but just not involved in the proceeding. And that causes this complications on its own. This is the state's plan for you. So the goals of planning for us: protect your assets, establish your legacy, maintain and grow your assets, and leave that family name the way it's supposed to be. Right? Because we didn't do this for nothing. Like, really. How many in here, it was easy to get all that money and assets, right? Yeah. It was real easy for you, wasn't it? You just rolled out of bed. Was it easy for you? It was easy. How many parents took care of everything? How many people's parents took care of everything the right way? Raise your hand. We got 1, 2 out of 20. 3. There we go. Parents talked about it. It was almost there. But they didn't get across that threshold. This is what I'm saying. It's not easy. It's not easy. We bump, we grind, we make sacrifices. We don't go on vacation for 2 years. We pay for college. And then we just give it all away to the state, or to the courts, or to lawyers. God forbid. Wait till I get to this other slide. And you don't want to have the same happen even if you don't get an estate plan. Because estate plans do fail. Trusts do go unfunded and then become invalid, right? Wills are written incorrectly or unclearly, and nobody knows what to do, right? So things do happen even when you're trying to do your lesson plan. So it's important, 2 things: that you get with somebody who understands what's going on, but understands you more importantly, and also you have to understand. I know a lot of lawyers who are so scared to have sit-downs with non-paying clients and just give them information. Which one of you in here want to draft your own trust? I'm not worried at all about telling you everything. I know you don't want to do the work anyway. But you should know. You have to know what you're doing. You have to ask the right questions. All right? So that's why we're doing this. We want you to know. We want you to be knowledgeable so when you go to your attorney, you understand where you can go with this estate plan. All right? So, fail a plan, poorly drafted documents, it'll fail, no permanent avoidance, it'll fail, it'll hurt you, no timely updates, it'll fail, it'll hurt you. And children, get inheritance, don't avoid bankruptcy, don't avoid remarriage, all those things. So, what are your options? We beat this to death a little bit, but what are your options to make sure you're starting a plan? So, option 1, last will and testament. Option 2, revocable and trust-based plan. We're not starting off with the most positive light on this side, but a will is better than nothing, right? Everybody should have a will. When I was coming up, even when I started out practicing law for over 17 years, what I was preaching most times is go out, get your will, protect yourself. As I grew and learned and went through some of my own personal experience, not only with clients but with family members, we started to understand that will-based planning is important, but not enough. It's not enough. Because when you do a will, what you're doing is volunteering for probate, right? And now, let's go back to some good features of a will, and we'll get to that. In a will, one of the things you can do is nominate guardians for minor children. That's very important, right? You're a parent, you may pass away, maybe you have a husband or a wife. That automatically is in their care, not an issue. If you're not married or your spouse is already deceased, that's going to be a problem. That's going to be a problem. Now, the other person, the other parent, when you're not married, obviously has a right and is going to likely be the one appointed by the court to have custody over the children. When you go with children of an individual who's born of that individual, you don't necessarily need to determine guardianship in that regard. But when it's an individual other than those people, or both parents are gone, you need to determine that. And you need to do it proactively, okay? If something happens, you don't get a second chance. It's the bottom line. So you want to name who you think is an appropriate guardian in case your children are minors to handle their personal problem. All right? You also nominate your executor to handle your affairs throughout probate. So now you have a good starting point. At least you manage the process of after you die. You're sending your assets where you want them to go, and you have your children taken care of just in case it happens before they can take care of themselves. But here's the problem with a will only. You mentioned that kids get the money at 18, really has trouble crossing state lines, doesn't really address incapacity, which we're going to talk about as well, as part of your estate planning. Incapacity is part of your estate plan. You got to know that. And they go through probate court. So, this will takes effect when you die. All throughout your life, nothing happens with the will, it just exists. So it's not even letting you manage your assets actively while you're alive. What happens in probate court? Probate is a court. It's a court where you settle your financial affairs after you pass away. My definition of probate court is a lawsuit that you file against yourself where the only outcome is you lose money. That's what probate is. It depends on where you're at. You might see varying numbers. The number I typically use is 5 to 15% of your estate dissipates through the probate process. That's lawyer fees, court fees, appraisals, all of that nonsense. Just because you didn't plan. Now, your children are down, your loved ones are down thousands, if not hundreds of thousands of dollars, just because you didn't do well with your estate plan. Imagine if you have a house in the state of New Jersey. Decent house, doesn't have to be extravagant. The prices in New Jersey are insane. Earlier, you're probably sitting right now in a $750,000 house. What's 10% of $750,000? You're willing to lose $75,000 just to go through a probate process? So, in probate court, what happens is the court appoints an executor, somebody to manage the affairs of the will. They may publish notice in the paper depending on the creditors, how that works. You inventory, you appraise your assets, you distribute assets, usually 12 to 18 months later, like a year and a half later. Everything is reported to the judge. You need court permission for everything. Imagine you have a rental property, 10 units, good income. You pass away. Now we're in court. Appoint an executive. 60 days minimum. Now you get your executorship. Do you need a bond? Now you go get a bond. Now you want to try to wrongly collect rents. How many people are behind in rent now? Because you know if the owner ain't around, ain't nobody paying. Now you got to go to landlord-tenant court. How much that's going to cost? If you hire us, it's going to cost a lot. No, I'm just kidding. You got to go to landlord-tenant court now. And we didn't even talk about the money it costs to file the probate action with the attorney. And now you're evicting the tenants. Now you got less income in the building. Now you got to go hire a real estate agent. And pay them. If you had a trustee, if you had a trustee, you don't get that. So, we talked about it. Probate is expensive. It's time consuming. The last one I didn't say is public. Everybody knows what Miss Smith did with her stuff. She hated that kid and I knew it. That's why she left it to that guy down the street. Everybody's gonna know. I don't want everybody to know my business. I don't know about you. So, if the will failure is not right for you, is not giving you what you need for your estate plan, the second option is trust. We have on the screen revocable living trust, and that's the purpose. We'll get into the types of trust. But trust-based planning is more comprehensive for you, better for you, so that you can have all your needs addressed with respect to passing on assets, guardianship, incapacity. And then let's talk legacy. How many generations are we leaving this asset for, or these assets for? Right? We need to think about that, because we can make it happen with the trust. Now let's talk about a trust in general. A trust has three main roles in every trust. The grantor, you all who are going to get a trust and put your assets in a trust. You're the grantor. You and your wife and your husband, or you individually. The trustee is the person who manages the assets of the trust. Typically, in a revocable living trust, the grantor or grantors are the initial trustee or trustees. So, you maintain your control over your property, but you take it out of your estate. By putting the property in the trust, you take the property out of your estate. Property that's not in your estate is not subject to what? Man, this is smart, man. And that's why we're playing this game. You're trying to take as many assets out of your estate so that you don't have any or very little assets to probate. All right? Beneficiary, who's entitled to receive the assets? All right, so three roles: grantor, trustee, and beneficiary. Grantor and trustees in a revocable living trust are generally the same people, initial trustees. You will have to think about people who are going to come after you and serve that role. It's very important. We'll get to our important people, our power people, if you will. So let's talk a little bit more about a revocable living trust. Obviously, you're going to name the beneficiaries, the people you want to receive your assets. Within weeks of your death, everything goes right, you're buried and everything. The trustee, the successor trustee, is now going to step in and start managing that property. So guess what? They have a certificate of trust. They don't need anything from the probate court. The deed is in the name of the trust. They have a certificate of trust showing that they're the trustee. It's their authority. They go knock on the door. Where is my rent? Who are you? Here's my letter. Here's my certificate. I'll give you a couple of days to, get used to the concept, but I'm coming back to collect my rent. Now you have no vacancies. You have no landlord-tenant court. You have no realtor. And you keep getting that income in to support your loved ones. Within weeks, the trustee steps in and starts managing the property. Okay? Now, what you do with this revocable trust, you set in place the rules that you are going to be governed by, the successor trustee is going to be governed by, and it tells everybody how you want your assets dealt with. The trust is revocable, meaning you can make changes. You can make changes, you can change the trustee, you can change the beneficiary, you can terminate the trust, it's revocable. It gives you that flexibility to deal with your assets, okay? So, you're still in control, but the ownership is now with the trust. If you're feeling the itch to say, own nothing, control everything, please don't leave. That is, these mantras. Just know that it doesn't quite work like that, right? So the point is, I am using the words, but I don't want you to get caught up in the hype of the slogans. It will be taken out of your estate, and you will still be in control of it. Now, more on the revocable trust. Right now, everything you own is outside of your trust. And you want to get it into the trust. You get it into the trust by what we started out with, changing the title to the asset. So you got a real estate. What's the title? What's the title document for real estate? What's the title document for a car? They call it a car title, right? But it's actual. It's not, let me put a list of my assets on the schedule and those in the trust. There you go, proof. Don't work like that. You have to actually make the transfer. You have to actually fund the trust, right? So you get a new deed written, you go down to DMV, you get a new title written. You buy a new property, you want it in your trust that already exists, you hand over the name of your trust to the title officer so they can prepare it, or your lawyer so they can prepare the deed properly. The assets have to be transferred, actually transferred in to the trust. Now, you're going to still be living in the house? Yes, question.
The will, if we have a will and it's put into the trust, do you have to label each thing in the will, in the trust, or the trust encompasses the will itself? How do you determine? Okay, let me back it up. The grantor and the trustee are the same person,
Yes.
right? The beneficiary, could that be the same person also?
In certain contexts, yes.
Okay, now.
But I don't want you to get derailed by that fact. That's really not important, I think, on which you're going. So just
But we're moving the will into the trust. How exactly, do you have to label everything in the will in the trust, or how does that work if you start distinguishing what's in the trust? I see you're getting to it now, but I'm somewhat lost in that transaction.
It's a great question, but you're right on point. So you have a will now. How many people have a will right now? Perfect. When you do a trust, it's advisable to do a new will. First of all, if you try to do it that way, it's going to be inconsistent and could possibly invalidate the document. So, if you had a will and you wanted to mirror some provisions in your trust, right? Who owns the property? Where is it? Right? So that's the reason why we said we would redraft the will. But here's what we will combine as a will with your trust. Everything you have in your will right now, let's say it's lined up like this, sir. My house on Oak Street goes to my son. My car in the garage goes to my daughter. Or my jewelry goes to my niece. You take all those, put that in the trust, those same provisions. Now your will is called a pour-over will. How many people know what a pour-over will is? A pour-over will is pretty much exactly how it sounds. And we're going to see it again back. When whatever assets are still in your estate gets probated, they then are poured over into the trust. The will sends your assets to the trust, right? So, the name of the game for clarity is as follows. You, as an individual, want to remove as many assets as possible from your personal estate so that you do not have to go through probate. There may be a situation where you still have assets titled in your name when you die, even though you have a comprehensive estate plan. It might be on purpose, or it might be by accident. To the extent that you have any assets in your personal estate when you pass away, the purpose of the will says, take those assets and send them to my trust. Now, what happens, sir? Those instructions you had in that will before, we already copied and pasted them there in the trust. So everything you wanted that you had in your will is being done by the trust. Everybody understand that? We can go over it again, but that's how you do it. Because if you leave everything in your will, you got a nice, just like you want it, it's going to go through probate. So you got to take those same desires, those same ideas, and put them in the trust. Did everybody hear that question? If you put your personal residence in a trust, do you lose control of it? The answer is no. In fact, nothing really changes with respect to even how you file taxes. Because you're the trustee, you're still in control. The IRS says if you have sufficient control, then it's taxable to you. So the fact that you're the trustee, the fact that it's in the trust, really changes things for probate primarily. We're going to get to other things that changes. And also, you do everything the same as far as I'm concerned. Tax returns, you living there, nobody can kick you out of the trustee, right? You're running the property. So let me step back and be clear. When you transfer property to the trust, the property is under the management of the trustee. Who is the trustee typically in the revocable living trust? You. If you desire, you can designate someone else. And we will talk about why that would make sense. But typically speaking, in revocable living trust, the grantor is the person who is the trustee or trustees. Okay? Now, let's go forward. A trust really solves the word problems. Here is a different version of what you use in court, probate court. 1 to 7%. I don't want to lose one, half. I don't want to lose anything. Okay? My estimate was higher. It's too much money. Assets go to your family in weeks, not years, and it's totally private during your life and death. Other benefits of an RLT, short for revocable living trust, easily change. You can update it at any time. You can use it across state lines. It's really difficult for creditors to attack if you have it set up properly, you manage it properly. You don't need a separate tax identity, which I just mentioned. You revocable living trust. You're going to be filing your taxes the same way, on the same way. After it's created, it's not difficult to maintain at all. No, you got to pay on it monthly. You pay for the trust to be set up. It's set up. That's it. The only thing we're paying for is all those assets you're buying and putting in there. That's it. And just to give sort of a visualization of what a trust is, it's like putting all your assets in a backpack and taking it with you, right? You just stuffing it in there, anything you want. Somebody might say, hey, well, do I have to put everything in one trust? No. There might be a reason to have separate trusts for different reasons. And we can get into that on a case-by-case basis. But at the end of the day, think of it as you stuffing all your valuables in your backpack and taking it along with you, right? When you transfer assets to the trust, that's called funding the trust. That's what it means by funding the trust. If you're not ready or you don't have it set up, but you just want to get it started, we'll do $10 cash to the trustee. And then the trust is funded and valid. I'm sure it begs the question, is like, well, is this right for me? Do I have enough assets for it to make sense? we kind of give two answers to this because you gotta be real. The first answer is, it's everybody. It is. However you want to plan and protect your assets, you do. Types of trust you get may depend on the amount and the level of assets you have and how sophisticated you need to be in protecting them and organizing them. So you might say, okay, you can start thinking about revocable trusts when you're, maybe over $4 million in assets because of all the interplays of certain things. So what about that? It doesn't make sense. No, of course it makes sense. But what we're talking about is more advanced planning with other people involved. For instance, if you have an irrevocable trust that you need a separate trustee for, you think that trustee is going to do it for free? Anybody? No. So you're going to have to pay. When do you want to pay? When it makes sense. When it makes sense. I'm going to save on taxes. I'm going to have asset protection. I'm going to make this income, and I'm going to still give them a little something for managing the property so it's out of my control. So that I can get all those benefits. So that's the only reason why we say we're not belittling anybody's assets. We're not. The bottom line is estate planning and trust are for everybody. The more sophisticated you get, the more value in your assets. You probably need to think about even more advanced planning. All right. But let's give an example. We got Pearl and Calvin. Pearl has $100,000 in the bank account. She wants to leave it to her grandson Calvin. Calvin, she wants him to be at least 25 and have graduated college. Right? Because she worked hard, but she wanted to give him a little bonus at this starting in life, but she didn't want to just be, just messing around. Mm-hmm. How can she do that? Can she do it with a will? So let me just say this. Yeah, she can't do it with a will. That's the point. She cannot do it with a will. In a will, you give it to him, it's over, right? The executive is managing the probate process, right? So there's not necessarily someone in there to be watching over Calvin. But with the trust, there is. That's the trustee's job, to abide by the trust rules that you set up, right? And so if Pearl wants to give her grandson Calvin $100,000 at 25 when he graduates from college, she needs the trust. She can't do it. That's not $4 million. But she still wants her wishes met, right? So she goes and gets trust. That's what I'm saying. It's for everybody. It depends on your circumstance, but it's for everybody. Now let's talk about children, minor children, right? And adult children, as they become adults. One of the things that parents are going to do is try to plan well for their children. You can give it all to them. You can give it to them at a responsible age. A lot of trusts that I draft for parents with minor children, this is how they leave their children, their legacy. They say, you're going to get 1/3 at 21. You're going to get 1/2 at 25. People do something third, right? That makes sense. That's math-wise, it doesn't work out that way. If you do 1/3 of the last 2/3, you know what I'm saying? So it's 1/3, 1/2, and then 1/2 at 1/3, right? People like that. Let them mature a little bit, let them earn on their own. And that's a good setup, At 30, I was doing okay with money. But yeah, that's good. Another way you could do it is, hey, we got this 20-unit apartment building. It doesn't have to be a 20-unit apartment building, but I'm just making a point. And why would we just sell it? Why would we just sell it and distribute money? Why wouldn't we collect 20 units worth of rent for our whole life and then pass it to our children? So many ways you can use real estate for financial gain. Why wouldn't we just sell it and give it to them at 21 and 25 and 30? That doesn't really make sense unless you just take it and let them do that. I don't even want to worry about that building. People are crazy. But if you keep it, you can give them a life estate. They get income for all their life. The building is still there, then it passes to the next generation for them to collect income. And you got the trustee in place, and you got your successor trustee, and you got the successor after that. That's real generational wealth. And you don't need to have $4 million. Maybe you need a 3-unit apartment. whatever. But the point is, everybody in here is really close to that being a reality, not already a reality. It really is. And we gotta see it that way. But if we don't plan, it's just gonna all go, please. Certain states you have like air property, which you can do deed as well. It's not a very robust solution. And then you also have more direct attempts to make what you're calling a dynasty trust. Probably made popular by Rockefeller mostly. J.D. Rockefeller, how he set up his trust for his fans, he typically dubbed the Rockefeller Dynasty Trust. And you do that in a very specific way, but it's intended to last for as generations. It's intended to last for generation after generation after generation. The way they keep it funded is a lot to do with interplays with life insurance and loans from the trust to the people, and then when they pass, the life insurance pays back the loan and adds more to the estate. It's a great little setup. It's good, but you certainly can accomplish a dynasty trust where your legacy just goes on and on and on, so long as this trust is still financially viable. Yes?
This is property. You can live on that. Say if you have a parent that left you 5 acres of land, and it's heirs property.
Yeah.
You can't sell that property. You can only live on that property. Am I correct?
Yeah, pretty much. Yeah, it's set up that way so it stays in the generations forever. It doesn't mean you can't make income from the property. It just can't be alienated. It can't be sold out. Oh man, good Mitchell family. Frank D. and Mo Miles. Everybody remember Mauricia? What happens? Mauricia got married to Q. She inherited funds, commingled with her other assets. Why do we say that? Why is that an important point? She inherited funds commingled with other assets. Because when even if you're married and you inherit money, it's not marital property. That's your property. So long as you keep it separate. How many people get that inheritance and put it right in that joint bank account? Boom! Now we got $300,000. It's gone. It's his and hers now. It's not just yours. She never did that. Keep it separate. So Mo got that inheritance. She put it right in the account with Q. They got divorced. Q gets half. That's not what most parents intended. Not at all. That's why you set up a trust. Moms, left water running in the bathtub, messed up his apartment. Downstairs neighbor, pissed off, sued. All of that is gone. If it were in a trust, what would be accessible by creditors? Really only the income given to them. Not that principle of all those assets in the trust. Only the income periodically given to them. So it's very important that we plan, especially when you have children in mind, in a thorough way. So a children's trust is a good example. It's like a tube of toothpaste. It holds ownership in mind for inheritance, like a tube of toothpaste. Kids can squeeze money out when they need it, but the remainder of the tube is protected from lawsuits, bankruptcy, divorce, and you can picture a trustee, all right? To protect your children's inheritance that you set up for. Nation. They always seem funner when I put them in, and then I get to the seminar. So let's talk a little bit about guardians, right? As I mentioned, you're not going to be able to designate guardians in your will. So in your trust, this is where you're going to nominate your guardians if you have minor children. Another thing that you need to think about is if you have a developmentally disabled or physically disabled child, someone with special needs, right? You want to think about that, who would be the guardian of their property and person. So in your trust, you'll be able to nominate the guardians, especially temporary. Temporary guardians are very important. They do not have to be the same as your permanent guardian. Anybody can take a guess why temporary guardians are really important? Temporary guardians. Anybody want to venture a guess? No brave souls. Okay. That's a great reason. But I'm not a fear monger, but think your worst fear. Where would your children be if you don't have a temporary guardian designated until you get everything straight out? Where? That's true. But where the kids going to be residing? Foster care. In jail. So you can have a permanent guardian all you want. That's good, because you know, long term, this person's going to do a bang up job taking care of my child. What about that 6 weeks, 3 months, 6 months before the proceedings are done? What? I would come back and kill myself. You know what they did too? And that's so true too. A long time ago, they told you, we sat with church and state. You gotta come get with the state to be legal. The church, I can do whatever y'all want. We're not gonna bother you, but they don't have nothing to do with our money. That's what your purpose was. By your pastor. But you wasn't told that by a neighbor. No. Okay, here's the best part about being a godparent, right? So, Dwayne, my brother, he lives here in New Jersey, right? My older brother, who I don't speak to, lives in California. And in court, he's the likely, my brother, person to be the guardian. But he doesn't know my kids at all. Dwayne doesn't have a legal presumption right, but has a right to intervene in the action as an interested party because he has a relationship with the child. My brother and Dwayne are going to submit competing applications for the guardianship. And because of how great Dwayne is in keeping detail on my kid and all of that stuff, he's going to win. You understand? The court still has to determine the best interest of the child, even though your blood relatives have the leg up, they have a presumption. Okay? Now, incapacity planning is very important because just when you die, that 20-unit building is going to have a lot of unpaid tenants. If you get sick, have a stroke, or a coma, you can't do anything for yourself. Nobody has the legal authority to do anything for an adult.
Even a wife or husband, right?
Limited. Even a wife or husband, say it loud. Limited. So you have to plan. Man, you have a question? If you go to court, it's the second one, guardianship. You got it? 100%. But the person has to do that. You see what I'm saying? It's not just, okay, I'm a guardian. No, you have to go to court. You have to file a proceeding. You have to do all this stuff. So, Instead of doing all that stuff, we address it up front in our incapacity plan by designating powers of attorney, by designating medical powers of attorney, by drafting a living will, which are your medical directives, bury me, no life-sustaining treatment, if I'm pregnant, yes, life-sustaining treatment, those types of things. And you're also going to have your HIPAA privacy waiver, meaning you give authority to others to release your medical information to your power of attorney, right? Because they're going to need it so they can do work on your behalf. No.
No.
Family members could go to the hospital and say whatever they want. If the social worker there or a doctor there listen to them, then they listen to them. What's legal? Because that's not sustainable. That's, okay, at this hospital, they did what I said. Then I went to the nursing home, they told me to kick rocks. So what you gonna do, complain? So you need your power people. Your power people, your powers of attorney, right? They need to be above 18, I recommend 21. U.S. citizens, no issues, willing and able to serve. So when we do our powers, whatever they are, we always have an acceptance section. We don't want powers out there just that they're out there. We always have an so the power of attorney steps up and says, you're asking me to represent you, and I will represent you. I agree. Some people don't want to do it, so let's not get it twisted. That's why it's important that we bring them in and have them accept the appointment so that your incapacity planning is valid. You don't want it to fall in space. They're trustworthy, they can speak on your behalf, they're responsible and organized. Those are some characteristics. Who that might be exactly in your life, you don't know. But I'll give you something so we kind of dispel some of the, standard thinking on it. Husband and wife, yes, it makes sense if you are powers of attorney for each other. You do not have to be, you should take it personal if your spouse makes a different decision. Because frankly, it's not your decision, okay? That's one. Second, if you only have a GED and his sister is a nurse PhD, and he appoints his sister as his medical power of attorney, don't take it personal. He just wants somebody that's knowledgeable that can provide the best opportunity for him to be healthy. And everybody has that right. I'll give you another example closer to home. My power of attorney is my friend Ibrahim, not my wife. Ibrahim is super wealthy, super rich, that's the same thing, and extremely responsible with his money. That's what I chose. And I know he won't even be willing to do it. So it's really, really your choice, but make sure it's the right person. Don't just do it they're going to get mad if I don't do it, so I'm going to give it to a brother. And you know you're going to steal it, and you'll lay up in the hospital. You can sue him. If you have money, that's not a contingency case. If you have anything left over. In any event, incapacity is very important. It's very important because we're sitting here, we're hanging out, and I can go outside right now and have a stroke. We can't play around with that. Y'all know stuff happened to people, y'all know. So let me tell you a story before we get to our process. Recently, I was working with this couple, and they were really like spooked. Their kids are in college at different colleges. They have good friends who also have college-age kids. They all grew up together. One of their friends' kids had a coma in college. Got into a car accident. Parents, they're mortified. They go out there, and the doctor's like, what are you doing here? Like, we're the parent. Like, we don't need you here. Why? She's like, no. What do you mean? We don't care, get out. No, that's not what happened, but that's basically how you feel when you go see your little 18, 19-year-old in a hospital and you can't say nothing. We have to talk to young people about incapacity planning too. Because you can't say nothing on their behalf. Nothing. Imagine. Your child, I'm thinking about my child? Can't. So we were on the phone last Sunday. Yes, I work on Sundays. No disrespect, but people have schedules. And the young people understood. They were very happy their parents were forward thinking. They were very willing to do it. We're doing it tomorrow again, and they'll have their incapacity documents so that they can be protected in case something happens to them while they're in college. Stuff happens. Stuff happens, and we need to be protected. Any questions? We're right at 11, so I'm not going to hold too long. We're going to talk. I got you here. We're going to go right through. Our process is 100% virtual, kind of. It can be in person. I still like in person, but it's very efficient to do virtual. 15 to 30-minute initial consultation. We get you the basics, we get an understanding of what you're looking for, and we set up the next step, which is our design meeting. That's where we design your estate plan and ask you all the tough questions so that we can get it right. Between the design meeting, you got to start thinking about things. The power of people, how you want your beneficiaries looked after, which assets you think are going to go into the trust initially, those types of things. Then you'll have your signing ceremony. We call it a ceremony because we're just not plopping down papers in front of you and telling you to sign with a little orange tag on the end. We are walking through the actual document we're getting ready to sign, making sure you understand it, making sure you don't have any questions, and most importantly, making sure these are your wishes and no one is forcing you to do it. After we do that, we sign everything, get it nice and bound for you at the office, and then we send you your beautiful binder with all your documents in it. You put that in a safe place. What don't you do? Do not hide. We grew up in generations where you do your will, nobody knows about it, nobody knows where to find it, and everybody's mad at the end because you didn't leave them what they expected. You know what that leads to? Useless challenges that cost money. Let me tell you a little secret. You know how good people are at lying, right? Intelligent people are good. They can smooth. So in the court, there's a thing where if you have a bona fide dispute in an estate, you can make an application to the court to have your legal fees paid by the estate. Do you know how good people are coming up with bona fide reasons to challenge yourself just to see if they get lucky, and then ask the estate to pay their attorney's fees? Not to say it's always be granted, but imagine. Guess what avoids those things? Telling them straight up. Here's my trust. You see these two cute people right here? These are my beneficiaries. Your ugly self is not on the list. They're not going to go to court a lot when you tell them to their face. I'm telling you, it works that way. But when you don't tell them, you sneak in, you keep it in front because you feel guilty, they're going to say, no, she was feeling guilty because she's supposed to leave me something. So we also add in a family meeting so we can explain everything to anybody who wants to be there. We encourage you to bring your power people there so they understand what role they're taking on. If you're disinheriting anybody, bring them. This whole thing is not a good feeling, right? Thinking about you dying or getting sick. So sitting down next to the person you're not giving anything to either is not going to be good, but we're going to get through it. About an hour, we can deal with it. And then it'll be over. You don't got to speak to them no more. They ain't going to want to speak to you anyway, so you're good. So that's our process. If you're married, you need both spouses to attend. We'll give you access to what we call our vault. We'll be able to fill in all your information. We'll answer your questions, discuss your goals. We'll select what package is right for you. We require the fee up front and full. We always talk to people about whatever circumstance they have, and we'll work with you. We are not, we don't get rich off this. We get rich off all other stuff we do. You guys see, But we really think it's necessary for the community. I grew up in this practice, and I've seen so many people use their assets just by not planning correctly. And I want to make that change. Our people have been doing much better than generations past, and we need to continue that momentum so we can support the generations coming behind us. These are our packages with respect to our estate plan. We'll do a will for you with your incapacity documents and everything. It may be appropriate for you. Let me give you an example. New York is real quick. In New York, I know New Jersey people, but just when a will might be appropriate in our trust. Again, not going to put wills all the way, but we do understand there's sometimes practical concerns. If you don't have specific instructions, if all your people are all adults and whatever, and you got a few assets that you just want to give to them and let it be done, make the wills appropriate for you. In New York, they have a proceeding where if your entire estate is under $75,000, it's an expedited proceeding, it's a cheaper proceeding, it's fairly efficient, so you don't get killed with wasting your time and money. So in that context, that might be appropriate for you, right, in those types of situations. The gold plan, you get everything in the silver plan, you get a basic revocable trust, you do one deed transfer to your home, to the trust, you send a notary to your home to execute all the documents. It doesn't include multiple asset transfers. I want to talk to you a little bit about asset transfers. I know we're a little over, but we're almost done. Funding your trust after you finish with us can be very straightforward. We give you what we call a funding toolkit, right? I'm buying real estate, what do I do? Look at the paper, it tells you. I'm on bank account in the trust, or I'm on designated trust, right? So that helps you. You can certainly come back to us and get guidance. Some people, a lot of people, I'm telling you, that's why I'm worried. People don't want to do the work. They want us to just do everything. Do the transfers, right? Do everything. And so then you're in the platinum package where you're going to get more asset transfers that we'll do for you. Same deed. It will also include the cost of deed recording as well. And give you a family wealth inventory, which is a pictorial of where your assets lie. That's very important, especially if you're looking at your books and want to adjust it over time. So those are our basic prices. We do other work, as I mentioned as well, that you can talk to us directly about. Right now, we want to welcome you to come work with us. Anyone from this seminar who studies the design meeting over the next couple of days, I'll just say by the end of next week. I don't even know if I'm going to be in office on Monday. And we schedule for the next 3 weeks, automatic $250 credit toward your estate plan. Now, if you found this information helpful, informative, please share it with others. I want everybody to be informed. I want you to know what you're getting into and go to it with gusto. We'll be more than happy to do a seminar for another group. Individuals with questions, please reach out to us and contact us. We gave you a worksheet. We would love for you to fill out. We're going to collect that from you. We'll add you to our mailing list and keep you informed, updated, and also contact you for any special announcements from our firm. Any questions at this point?
Yeah, one question from online. It says, is the objective not to go through probate? Is that bound to happen?
The objective is not to go through. The objective is not to go through probate of a lot of assets. Because you're gonna have a pour-over will. So what does the pour-over will mean? It gets submitted to probate. But hopefully, there's really nothing in that estate to probate. The objective is to avoid probate as much as possible. Yes.
Somewhere in my head, I heard that was it a beneficiary, like for an account, overrides a will?
Yes. So when you do pay-on death designations or beneficiary designations, those are outside the probate estate. But the problem is what I mentioned throughout. It just goes directly to the person. Is that what you want? If that's what you want, it's all good. If you don't, and you want to set it up in a way that's staged or appropriate for that person, then you got to do it in more planning about that. Sure.
fees, is that paid up front while you're in probate? Like, let's say it was an 18-year-old or a 19-year-old. Where's that money coming from to pay all of these fees, real estate fees, lawyer fees, while it's in probate?
Whoever gonna step up,
What if they die?
that's
And
the
we get money
problem.
from the
That's the problem.
state. So
That's
God,
the problem.
then what happens?
It is sit. Somebody will step up and say, hey, nobody's submitting the will, so I'm gonna apply for administration.
So you have to pay it, I'm saying, you gotta pay the fees as you.
Well, if you go to a lawyer to represent you, well, you can do it yourself. Most surrogates offices are very friendly to the public, right? But when you go to the surrogate office, guess where you're not going to be at? Work. Guess what you're not going to be doing? Hanging out with your grandchildren, right? So you can do it yourself, but if you hire an attorney, they're likely going to require at least something up front to get started.
So you need some upfront money.
You need upfront money.
Can't wait till that will pay out.
That's why you need a bank account in the trust. I let my partner make a few remarks. You all have been amazing, and I would welcome any opportunity to work with you all again. Have a great day.
Good morning, everybody. My name is Dwayne Lattimore. Marquis introduced me earlier. I just wanted to say, one of the reasons why I'm talking to this guy is because of his passion to make sure that things go right for people. All this pre-planning that Marquis is talking about, I actually sit on the other side of it. We argue for people that are in court because somebody's just come out of nowhere claiming to have access to some type of right to the person's property. And we got to sit there and defend that person. And unfortunately, like Marquis has mentioned, money is coming out of the estate just to pay us attorneys to fight for something that was rightfully belonging to the heir. And of course with receipts, which is because that person had trust set up. Now they need to go ahead and hire somebody like Abraham Lattimore to come in, fight on their behalf. And that is expensive. The market's just like we're like this. We can lose on the other stuff. So, I'm a person that, I came up in the church. 8 years old, I was at Calvary Baptist Church. Happy to be an usher. My mom was an usher. My father was a deacon, so I was very happy to sit there and, with my white gloves and stand and usher people to their seats and to the pews. So this brought me, right back home. And we care about you. I just want to let you guys know that, this is more than just about. It's more than just about us being lawyers. We want to make sure that people aren't being represented. Like I said, I see the ugly side of things, and it bothers me. I started out working in big law firms, and I wanted to help people. And the big law firms would tell me, you can't go help that person because you represent this bank, and that will put you on the other side. You just can't do it. So I left the big law firm, partnered with Marquis, so that I could help individuals here. Because I also have a family that's actually in the church. And this is what's important to me. So I just want you guys to understand what Abraham and Lattimore is about a little more. We're here not just to, help you do a state, but to be a listening ear. You guys have questions about anything, you give us a call. It's not just trust in the states, we do a lot. And we want to know what's going on. We want to pay attention. We want to be able to help, and we want to assist you in every way that we can. So, again, thank you for allowing us to be here. I'm very happy to see all of you. I'm very glad that you all are interested in stuff. And feel free to reach out to us. You guys have our contact information, but if you don't, just let us know. And also fill out those sheets, and we will make sure that we reach out to you in the near future, just to say hello and things doing this. All right?
I have another question.
Sure.
Are trusts better for helping you protect your assets if you did plan for long-term care for your elderly?
Yes, you need a couple things with that. We definitely are going to be talking to you about a dedicated asset protection trust, right? You can do it in various different ways, but if you're looking toward that, absolutely, we prefer to do the proactive planning rather than the crisis planning in that regard. So yes, you can use trust to help you still qualify for Medicaid and still maintain your assets.
One question, the power of attorney, can it be a beneficiary?
Yes. Yes, the power of attorney can be the beneficiary of the trust. Thank you so much. Yes, yes.
I gotta go.